or life imprisonment without the possibility of parole. The final decision as to which punishment shall be imposed rests with the judge of this court. However, the law requires that you, the jury, render to the court an advisory sentence as to which punishment should be imposed upon the defendant. The state and the defendant may now present evidence relative to the nature of the crime and the character, background, or life of the defendant. You are instructed that this evidence, when considered with the evidence you have already heard, is presented in order that you might determine first whether sufficient aggravating circumstances exist that would justify the imposition of the death penalty, and second, whether there are mitigating circumstances sufficient to outweigh the aggravating circumstances, if any. At the conclusion of the taking of the evidence, and after argument of counsel, you will be instructed on the factors in aggravation and mitigation that you may consider. The attorneys will now present their opening statement.
May it please the court? Good morning, members of the jury. Over the next few days, you are going to be asked to make one of the most difficult decisions you may ever be called upon to make. Whether to recommend that the defendant, Michael Bargo, be sentenced to life in prison or to death. I want to take just a few minutes to give you a brief overview of how this part of the trial is going to work. Now, the testimony that you hear during this part of the trial is to be considered along with everything that you heard during the guilt phase. All of the testimony, all of the evidence, all of the statements. And since during that portion of the trial, the guilt phase, the state presented some 40 witnesses, with testimony from some 40 witnesses. At the beginning of this part of the penalty phase, we are not going to present any more testimony from any more people. However, after the defense presents their case, we do expect to call rebuttal witnesses. Now, what you're going to hear is that there are certain things that make a death penalty case, a death case more serious. These are called aggravators. And these aggravators are set out by the legislature. And what we have to do is prove one of those beyond a reasonable doubt. And that's something, in this case, that is the same as in the guilt phase, is that the state has the burden of proof. We still have that. And that burden of proof is still beyond a reasonable doubt. But, in this case, unlike the other case, the guilt phase, guilt part, we had to prove elements. And that was the elements of first-degree murder, beyond a reasonable doubt. Those three elements. What we're proving here are those aggravators. And those aggravators set out by the legislature is what's going to make one murder more serious than another murder. And the proof of one of those aggravators, beyond a reasonable doubt, is what makes it possible for a particular defendant to be sentenced to death. Now, there are 15 of these aggravators that are set out by the legislature. And there's no case where all of those aggravators apply. For example, one of the aggravators is that the victim of the capital felony is under the age of 12. That clearly doesn't apply here. The judge is going to tell you what aggravators apply in this case. And what we expect to prove to you beyond a reasonable doubt, one of the aggravators is something called cold, calculated, and premeditated. And the judge is going to describe what that means to you. But what it is something more than simple premeditation. It's something conceived, well thought out, organized, with the purpose being the death of the victim.
Objection, Your Honor. I believe counsel's getting into argument.
Overruled.
You've already heard evidence in this case during the guilt phase of how everybody in this case had a part. They had a role. They planned out what every person was to do. Before Seth was killed, they had planned how they were going to dispose of his body. They were going to burn it in a fire pit. And they described how they were going to get rid of the body, throw it in the lime rock pit. And they ultimately of how they were going to lure Seth to his house. This aggravator, cold, calculated, and premeditated, goes to the nature of the crime itself. The second aggravator that we intend to prove to beyond a reasonable doubt is called heinous, atrocious, or cruel. And what this aggravator goes to is how the act of the murder affected the victim, Seth Jackson. How the victim, Seth Jackson, felt when he went to Charlie Ewing's house, expecting to make up with Amber Wright, and instead was ambushed by Kyle Hooper, Justin Soto, and the defendant Michael Bargo. What thoughts were in Seth's mind when he escaped from that house, only to be stopped, beaten, and dragged back in? That's what that aggravator will go to, how the victim felt, how Seth felt. Now, if you determine that we haven't proven one of those aggravators, beyond a reasonable doubt, your discussion ends. You have an obligation to recommend life in prison if we don't prove one of those. But if we do prove at least one of those aggravators beyond a reasonable doubt, then you will consider and weigh that aggravator or those aggravators against the mitigators that will be presented by the defense. And in the end, we're going to ask that you carefully weigh and consider the significance of those aggravators that we've proven to you against the mitigators that the defense presents. And ultimately, we will ask that you return a recommendation of death for the defendant, Michael Bargo. Thank you.
Ms. Hawthorne?
Good morning, Your Honor. Good morning, Ms. Arnold, Mr. Holland, Mr. Bargo, good morning. Mr. Ernst, good morning. Mr. Chilton, good morning. Ladies and gentlemen, this is probably one of the most bizarre cases that I've ever worked on. Aggravation mitigation. In this part of the case, the defense expects to show you an inside view of Mr. Bargo's life. A life that, up until the age of 7, was Disney-like, picture perfect. Then things started to change. He was born in 1992. In 1999, he was 7. In that year, his sister was born, Lauren. In that year, his mother took him to the pediatrician, and he was diagnosed with ADD, ADHD, and he was prescribed medication. Ritalin. You will hear facts surrounding probably one of the most nasty divorces that has ever occurred, and the victim is that young man over there who was sabotaged by his parents. A mentally ill young man who was emotionally traumatized and used between these two people to fuel their fight. So much so, he began to engage in self-sabotaging behavior. His school grades went down. His attitude disintegrated. He was very angry. In 2001, a family by the name of Christensen lived next door. And they shared some good times with the Bargos. They went camping and fishing all along, as this young man continued to disintegrate emotionally, become depressed, chronically depressed. He was suspended. He was expelled. He was having problems with his medication. He was admitted to the hospital a number of times with different injuries. Injuries that were caused by bullying, by domestic violence. He was kicked off one of the basketball teams because he kept getting picked on and he fought back. He was very tiny. He was always very small. He was bullied in school. And having the mental health problem that he had did not help him. He couldn't concentrate. He kept having problems. You will hear how the medication made him sleepy, lose his appetite. He didn't care. You will hear how this progressed later into suicidal ideations. You will hear how this young man had a very close relationship with his father. Very close. Incredibly close. And when the parents split, you will hear how he wanted to live with his father. But that wasn't going to happen on Mom's side. And the fight continued. Eventually, the Department of Children and Families got involved, and they counseled the parents about sabotaging their son. They got him into counseling with a psychologist who in the early months of 2007 wrote a letter indicating that Michael Bargo Jr. was a danger to himself and others because of his explosive rage caused by his relationship with his mother and the divorce proceedings. It had exacerbated. It had gotten worse. It had gotten so bad that the police were called to the home a number of times. One of the last times, he had crawled through a window in his house from his room and run across the street and called the police. At the same time his mom called the police to report him as a runaway, he called the police to report her abusing him. He wound up getting arrested, supposedly for having knocked a cell phone out of his mother's hand. He wasn't put in an inpatient treatment program like the psychologist had recommended. Long-term inpatient treatment, where neurological tests would have been done, MRIs, CT scans, PET scans. None of that was done because this young man was put into the Department of Juvenile Justice in Michigan for 2.5 years for knocking a cell phone out of his mom's hand. You will hear that all through this period of time, his passion to be with his father never wavered. I want to live with my dad. Finally, in August of 2009, the court released him and he was able to come to Florida. He completed his high school education at CTAE, earning a GED. He got jobs. He was trying to make a living. He was moving his life forward. He had girlfriends. And then a disruption in his life. And the experiences of what he had been taught, been shown, the balance of the equities that were never in his favor, finally created a circumstance where he found himself enraged. You will hear from some experts that have met with Michael several times, one that has met with Michael a number of times, has given him tests, has also given tests to his father. He has read thousands of pages of discovery in this case. He has reviewed reports, school records, evaluations, medical records, and he will come and he will give you his opinion on what has happened to this young man and how that connects to this horrible event. You will also hear from a radiologist who will come and he will tell you about a PET scan that was done on Michael's brain, and that PET scan came back abnormal. And he will educate you on what a PET scan is, what he does in his analysis, in his clinic, and he will share with you the insights of his training and how Michael Bargo's abnormal brain affected his ability to control his rage. When all is said and done, ladies and gentlemen, you will hear a number of mitigators. Now, some of the mitigators that will be presented are mitigators that our legislature have created. One is that the defendant has no significant history of prior criminal activity. The capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. The defendant was an accomplice in the capital felony committed by another person, and his or her participation was relatively minor. The capacity of the defendant to appreciate the criminality of his or her conduct, or to conform his or her conduct to the requirements of law, was substantially impaired. The age of the defendant at the time of the crime, the existence of any other factors in the defendant's background that would mitigate against imposition of the death penalty. Now, the last one, through time and development of the law, has allowed us to share with you events throughout an individual's life in order that you may see the connection of how they got to the point that they are sitting in this courtroom. Now, ladies and gentlemen, on Tuesday, when you decided your verdict, you decided that my client is going to spend the rest of his life in prison without the possibility of parole. You've already made that decision by your verdict. I would ask you to maintain that recommendation to the court. And I'm sure that once you've heard all the information and evidence, each and every one of you will agree with me that maintaining life imprisonment without the possibility of parole, considering that the word "they" has been equally used by the state, and that all the other participants are serving life imprisonment without the possibility of parole, it is the appropriate sentence. Thank you, ladies and gentlemen.
Will counsel approach the bench?